Oh,
Yes.
19. Your Lordship may make mention regarding item 18 and 19. These are the hearing items. I have taken the consent of the other side. This may be taken up on 19th of this month, my lord.
19th of this month.
Yes, 19th of this month.
What is your name?
B. Lalram Menga. I am for the counsel for the private respondents.
Learned Counsel Mr. B. Lalra Menga,
Yes.
representing the respondent number 3,
Private respondents, my lord.
representing the private respondents, with the consent of the other side, has prayed for adjournment. Learned Counsel Mr. A.R. Malhotra is present on behalf of the petitioners. List the matter on 19th.
Yes. Highly obliged, ma'am.
For motion, item number 1.
Your Lordship, there are certain connected matters, my lord, listed today also. So altogether, they have to be taken together, my lord. So for that, my lord, if the matter may kindly be taken up next week, Tuesday, my lord.
Tuesday.
Item number 1 along with item number 5 to 9.
Next week, Tuesday.
My lord,
Next
next Tuesday, my lord.
next Tuesday.
An attempt may be, I think an attempt may be made to dispose of the matters also.
On Tuesday
All
itself.
together, yes, on Tuesday.
We are for the respondent.
Yes, we are for the respondents.
Item number 1 to 5.
1 and number 5 to 9 and number 13 and 14 also.
Number 5 to 9 and
5
number
to
13
9.
and 14.
13 and 14 also.
13 and 14. Right. We'll club it together. Same order will work, or will pass the order separately? Same order?
Yes.
Common
Okay. Common order. Item number 1. Learned Counsel Mr.
C. Zoram Sanal also.
C. Zoram Chana has submitted that this matter may be taken up on Tuesday, as they are analogous matters. Who stop Learned Counsel Mr. Your name?
Mr. B. Lalram Menga. I am
Yes.
in item 6.
Oh, item number 6, huh?
Yes, for the respondent number 2.
Okay, okay. Only in item number 6, huh? This order is only for item number 6. Otherwise, the other orders is only relating to Learned Counsel for the petitioner. In item number 6, a separate order in item number 6. First sentence will stay, will remain, and the second sentence will be Learned Counsel Mr. B. I didn't get your name. You note down his name. Has submitted that this matter may be disposed of on the next date fixed. List the matter on Tuesday. What is Tuesday? 12th. Okay. On 12th.
Obliged.
For admission, item number 2.
My lord, in this case, the counsel for the respondent number 6, she is on leg in courtroom number 1. So if the matter may be passable for the time being and taken up as the last item.
All right.
Item number 3.
Sure, item 3, if this matter may come up after 2 weeks, Your Worship, I've taken the consent of the government advocate.
Learned Counsel Mr. A.R. Malhotra, with the consent of the Learned Government Advocate Mr. H. Lalma Somi, has prayed for adjournment. List the matter on when do you want? After 2 weeks. After 2 weeks.
Item number 4.
May it please, Your Lordship. My lord, this is a first appeal against order dated 0209-2024. Passed in airship certificate application number 1201 of 2023. We are putting that order to challenge due to the fact that the case was maintained on a ground that was not pleaded by the petitioner. No ground was pleaded on that particular point, and yet it was maintained on a different point altogether. That's why we're putting that order to challenge, and this is the first time it's being listed. So notice
We'll
may be
issue
issued.
notice.
My lord.
Learned Counsel, Mr.
Lalfakoma.
Lafakama is present for the appellant. The appellant to take steps to issue notice to the how many respondents?
1.
Appellants, huh? For the appellants. Appellants to take steps to issue notice to the respondent to register post with AD as well as usual process returnable within 4 weeks.
3 weeks, my lord. They're all listed in
Returnable
the
within
visor.
3 weeks. List
Alternately, your lordship, I may be allowed to take steps by way of dusty.
dusty service is permitted. List the matter after 3 weeks.
Deeply obliged.
Item number 10.
My lords.
Yes.
My lords, I appear for the appellant, my lords. This is an RFA, my lords. First appeal, my lords.
Yeah.
My lords, this is a case where, my lords, no evidence had been, my lords, tendered by the plaintiff therein. On that ground, my lords, this appeal we filed. My lords, along with this appeal, we filed a stay application, my lords. Because this stay application, separate IA, my lords. So, my lords, we're seeking that the...
Where is the order?
My lords,
Where is the judgment?
Yes.
This is against order or against contested judgment?
My lord, judgment. Judgment and decree, my lords.
Judgment and decree.
Yes, my lords. We've annexed the certified true copy, my lords. And also made it annexure. My lords may see from page 23 onwards.
In the appeal or in the
In my appeal, my lords.
application?
Application also we've annexed, my lords.
Let's go to the application.
Yes,
straight
yes, my
away.
lords.
Relevant part of the judgment without discussing the. Just point out the relevant part of the judgment without discussing the evidence.
Yes, my lords. My lords, the material part is at para. Issue number 4. And my lords, I'll take your lordships to straight to my lords, para 46. It was a money decree, my lords. Hence, the total amount of money payable by the defendant. Internal page 27. Hence, the total amount of money payable by the defendant to the plaintiff for the construction of Girder Bridge, Upper Khatla Aizol, and Sazek Bridge strengthening works, Rajiv Nagar, is amounting to rupees 54 odd lakhs, my lords. And the present issue is decided in favor of the plaintiff and against the defendant. And the order, my lords, is given. Upon hearing both parties on various issues, the instant suit is decided in favor of the plaintiff. Hence, the defendant is directed to pay rupees so and so only to the plaintiff within 3 months of the order, my lords. Further, the defendant is directed to pay rupees 10,000 only as cost of the suit. With the above, the instant civil suit is disposed of. Your lordships may see the next page. This is the decree, my lords. Same date. Further, defendant is directed to pay, my lords, at para 2. It is hereby ordered and decreed that defendant shall pay so and so amount only to the plaintiff within 3 months of the order.
We'll have to go to the grounds of the appeal.
My lords.
For a stay order at
Yes,
part A,
yes.
we'll have to go to the grounds of the appeal.
My lords, may I take your lordship straight to the judgment itself? That reveals itself what is, my lords, amiss. Because our ground is, my lords, that this judgment has been passed without the plaintiff tendering any evidence. And the learned trial court has, my lords, invoked the principle of evidence, principle of probability of preponderance of probability based on, my lords, no material, no evidence. Plainly on the assertion made in the plaint. And, my lords, no evidence even in...
You never know what is the conduct of the plaintiff, why evidence was not reduced by the plaintiff.
Yes.
You are the defendant or the plaintiff?
Defendant, my lords. I was the defendant.
Okay. It depends on the conduct of the defendant also,
Yes.
why evidence was not taken up from the defendant's side.
Yes.
So, let us go to the grounds of the appeal.
Yes, my lords. My lords, it starts at page 11 of the appeal book.
Please read the grounds.
Yes, my lords. For that, the impugned judgment, order, and decree passed by the Civil Judge Senior Division 2 is bad in law as well as on facts, liable to be set aside, quashed. My lords, there were 4 issues framed. First issue, my lords, is on maintainability. That we're not pressing, my lords. Issue number 2, whether the plaintiff is a subcontractor under the defendant or just a manager. This was the issue framed by the trial court. My lords, here, we've said that the trial court firstly failed to appreciate that no evidence had been adduced by the respondent plaintiff to prove the fact that he was engaged as a subcontractor for the construction work for Azol Lake and for Sazek Bridge. My lords, these were 2 works which was given.
So he didn't complete his work.
No, my lords. He
Why-
claims that, but he claims, my lords, that out of 100 rupees, I have given him 90 rupees. He's also further entitled to receive a further amount of 10 rupees.
Okay.
Yes, my lords. And we did not subcontract, my lords. I was the contractor in the works project given by the government. I employed him as an assistant cum manager, my lords. Thereafter, my lords, monies were paid in his discharging his role as a manager. Wherever expenses were required, I put it in his account. He made the necessary payments, my lords. Out of that, my lords, he had a share as his contract for employment. Now, my lords, he comes, he files this suit for declaration and consequential reliefs of, my lords, this in the form of money decree. There, my lords, only thing is he asserts, he puts evidence to the fact that he had some relationship with the contractor. Now, even if we assume he is subcontractor, my lords, the central issue is, can a money decree be passed without any evidence at all? There was no material, no documentary agreement made between the parties. It was all oral. There were no bills, there were no invoices to the effect that this amount is claimable by me, I am entitled. Simply on the assertion that I have a relationship, the trial court has said, since you have worked with the defendant in whatever role, therefore you are also entitled to this further amount. My lords, how can that be? That is the central issue, my lords, in this. Your lordships would go, if I may take your lordships to the judgment, that will make it clear, my lords.
All right. But
Yes.
let us complete the grounds.
My lords, my lords.
How you have, is it only 3 pages? Please read it.
No issue, my lords. My lords, ground C, for that the learned trial court had decided the said issue in favor of the plaintiff based on no evidence apart from bald averments made by the respondent plaintiff that he was engaged as a subcontractor, whilst also recording the fact that no evidence was brought by both the parties regarding the salary of the respondent plaintiff as manager. So, my lords, even the trial court says, I'll take your lordships to that relevant part. Further, my lords, learned trial court failed to appreciate that the annexures, my lords, these were the evidence given by the plaintiff, respondent in the suit, showing WhatsApp conversations. My lords, in this ground, we say that the plaintiff does not in any manner approve or indicate, along with these annexures, as to the nature of engagement of the plaintiff with the defendant. And additionally, as such, my lords, Section 65B was also of the Evidence Act was also not complied with. My lords would know 65B, my lords, the certificate. My lords, learned trial court failed to appreciate that the weakness of the defense cannot be a justification to decree the suit, especially when the plaintiff failed to discharge the burden of proof as mandated under Section 101 and 102 of the Evidence Act, my lords. The burden lies with the plaintiff, my lords, to prove the fact asserted. F, my lords, learned trial court failed to appreciate that the defendant did not have the authority to subcontract, as the PWD department does not allow the same without their express consent, and further assuming without admitting that such an agreement was formed between the parties, the same would be hit by the Indian Contract Act under the relevant provisions. My lords. G, my lords, learned trial court failed to appreciate that plaintiff witness themselves had made no averment to the effect that the plaintiff was engaged as a subcontractor, or that they had knowledge of the fact that such agreement for subcontracting was made between the appellant and the appellant and the respondent. It is also pertinent to state that the said prosecution should be plaintiff witnesses categorically stated that the construction works at the 2 sites were of the appellant. So, my lords, the plaintiff had got 2 witnesses. They themselves never asserted or made a statement to the fact that, my lords, there was some sort of subcontracting. But, my lords, let me come to the main issue. which is at, my lords, your lordships, we can come to page 15, issue number 4. Whether the plaintiff is entitled to the reliefs claimed, if so, to what extent? My lords, ground K. For that the learned trial court had erroneously decided the said issue in favor of the respondent plaintiff without appreciating the fact that no iota of evidence was ever led, produced, brought on record by the plaintiff to substantiate as to how an amount of rupees 54 lakhs 58,465 stood due and payable to the respondent by the appellant herein, much less accrual of right for recovery, my lords. Ground L. Learned trial court had failed to appreciate that the burden of proving the fact that the amount of so-and-so stood due and payable was on the plaintiff, which was not at all discharged. Apart from the bald averments made in the plaintiff, no other evidence, much less corroborative evidence or admission was made by the defendant. And thus the standard of preponderance of probabilities evidence was wrongly invoked, as no material evidence was led, much less produced on record, and failure to do so could not have resulted in decreeing the suit. My lords, I'll take your lordships to ground M again, my lords. Failed to appreciate, learned trial court failed to appreciate that without any evidence being led by the respondent plaintiff to prove a fact as alleged, the question of... Yes, my lord.
So which paragraph are you reading?
Ground M, my lords.
Ground M. Okay.
Yes. For that, the trial court failed to appreciate that without any evidence being led by the respondent plaintiff to prove a fact as alleged, the question of assessing a non-existent fact on the anvil of preponderance of probabilities / evidence could not have arisen, and as such the suit as filed by the respondent defendant ought to have been dismissed as not proved, especially when the existence of an agreement for the total amount of said works, this was alleged, my lords, rupees 1 crore 50 lakhs for the construction work at Azol Lay, and the alleged rate of rupees 150 per kg for the construction work at Sussex Bridge strengthening work between the appellant defendant and respondent plaintiff was never proved by the respondent plaintiff via evidence. For that, the learned trial court, my lords, ground N, findings as recorded are perverse, not being based on evidence, and that the reasoning being based on surmises, the said impugned judgment and order and decree ought to be set aside, as the same goes against the well-settled maxims. Affirmantis est prober, the person who affirms must prove, and affirmanti non neganti, incumbit probation. The proof is incumbent on the one who affirms, not on the one who denies, my lords. This is traceable to section 101, 102 of Evidence Act, my lords. My lords, ground O, for that the learned trial court had erroneous issue without rendering any discussion and decided the said issue the other two unconnected issues, that is issue number 2 and 3, framed by it without any independent discussion as to how the alleged amount of rupees 54 odd lakhs stood due and payable to the respondent by the appellant herein, when no evidence of such accrual of right was adduced to such effect by the respondent. Your lordships, if I can take your lordships to the relevant para
Yes, yes. Of the judgment.
of the judgment. My lords, I'm coming back to my application, my lords. Just refer from my application. But the internal page, your lordships can refer to that. My lords, I'll just take your lordships to page para 15 of the judgment, internal page 13, just to show what issues were framed. Para 15, my lords, 1.5.
Yes, para 1.
Whether the suit is maintainable. Second is whether the plaintiff is a subcontractor under the defendant or just a work manager. Third is, if the plaintiff is a subcontractor under the defendant, whether the work of subcontract was prematurely terminated. Fourth, my lords, whether the plaintiff is entitled to the relief claimed, and if so, to what extent. Fourth, my lords, is the money which was claimed. Your lordships, now I take your lordships straight to page, this is my lord, page, para 39, page 25, internal.
Yes.
Paragraph 39, my lords. Issue number 4, whether the plaintiff is entitled to the reliefs claimed, if so, to what extent. For determination of the present issue, the plaintiff stated that on 11th March 2018, the defendant contacted the plaintiff and offered the said construction work through telephone call and offered rupees so and so only for the construction work. That the plaintiff asked the defendant to increase a bit more, and thereafter the defendant offered another rupees 10 lakhs only would make the total
Just a
sum.
moment.
Yes.
The plaintiff is the engineer,
Plaintiff is the contractor,
contractor, and the defendant is the engineer,
alleged subcontractor.
subcontractor.
Yes. I'm sorry, my
So
lords.
this is between both parties only.
Both parties.
Private parties.
Private parties, my lords, no written agreement.
Oh.
It's all oral.
So this was from the PWD department.
My lords, the works were allotted by the PW department. I, my lords, as the defendant, was the contractor.
Contractor and the plaintiff is the subcontractor.
He claims to be. I say he's a manager, but let that be, my lords. Let us.
He
admit-
claims to be the subcontractor. All right.
Subcontractor.
Okay.
Now, my lords, there was an alleged agreement. There's no written or documentary agreement. And I had given him out of this rupees 1 crore 50 lakhs, an amount of 1 crore 1,50,000. This, my lords, I admit payments were made, but this was for expenses of material. Now, my lords, the further claim was of 48 lakhs 50,000. That is the issue, my lords. Para 41, I'll read on, my lords. That as per the exhibits P9, 10, 11 and 12, the total amount of money paid by the defendant, my lords, these were checks. The total amount of money paid by the defendant to the plaintiff for construction of girder bridge, that is Aizawl Lane, was given in check for 4 installments amounting to rupees 90 lakhs. And another rupees 11,50,000 was given through direct transfer to his bank account. And the total amount paid to the plaintiff is rupees 1 crore 1,50,000. With regards to the Sussex Bridge, this is the second works I had got, my lords. So with regards to the Sussex Bridge strengthening work, the plaintiff further adduced that as per the verbal agreement between the parties, he had executed the work at the rate of rupees 150 per kilo and completed 90% of the work when the severe flood struck them, to which the defendant paid rupees 3 lakhs by way of check, and the remaining balance is rupees 6 odd lakhs. So, my lords, together they are 54 lakhs odd. That's the total amount. Although the defendant denied almost all the plaintiff case, he has corroborated the total amount of payment he has made and stated in paragraph number 7 of his evidences that with the BHE's money, my lords, BHE is my proprietorship firm, the contractor. Money is being spent by the plaintiff. The value of all the works completed by the plaintiff was calculated to be rupees 96 odd lakhs. And that he has already given the plaintiff exceedingly an amount of rupees 1 crore 1,50,000 in installments, and out of which 10% of the amount of work completed by the plaintiff would be his salary. So, my lords, in this 1 crore which I've paid, that 10% which I was to give to the plaintiff as his salary, my lords, is included. In point number 26 of his cross-examination, the defendant denied the suggestion that while contacting the plaintiff, he proposed to the work for rupees 1 crore 40 lakhs. Also denied the suggestion that while contacting the plaintiff, he proposed to the work for rupees 1 crore 40 lakhs. And also denied the suggestion that he accepted to give a bonus of rupees 10 lakhs. In point number 27, he has liabilities amounting to rupees 48.5 lakhs to the plaintiff for Aizawl Lane and rupees 6 odd lakhs for strengthening works. So, my lords, these were all denied by me in the
Defendant.
defendant. Denied everything, my lords. Para 44, my lords. In the case of Teshi Shelley versus Tayyum Ete, decided on 2nd March 2006, the Honorable Guwahati High Court has held that in deciding a civil suit, it is preponderance of probability of the case of both the contesting parties that should be taken into consideration. The principle of strict liability, that is proved beyond reasonable doubt, is not required to be applied in deciding a civil suit. Para 45. Therefore, on the basis of the above discussion with findings in the foregoing paragraphs, this court is of the considered opinion that both parties made verbal agreement for execution of Girder Bridge Upper Khatla for a sum of rupees 1 crore 50 lakhs, only out of which the defendant had paid rupees 1 crore 1,50,000. Remaining balance of rupees 48 lakh 50,000 Only with the
So
remaining
according
balance.
to you, this decision was without any
Yes, yes, my lords.
evidence.
Yes, yes, my lords. Your lordships, if I were to prove, my lords,
You don't have a written agreement.
nothing, my lords.
No challans.
No challans, no admissions, my lords. The plaintiff witnesses also.
All right, you have a point. So if you have a point, are you agreeing to pay the decretal amount in the registry
My lords,
for stay?
my lords, if your lordships direct, my lords, I will comply. But my lords may take into one point into consideration, my lords, that my lords, today the appellant, my lords, is facing some financial distress. So my lords may
50% of the decretal amount?
my lords, if your lordships can, my lord, even considering the my lords appellant's financial distress, my lords may keep it somewhere around 10 to 15%, my lords. Ultimately, if I lose, my lords, he will get the amount. I cannot escape anyway my fate, my lords.
How much? 10 to?
10 to 15%, my lords. Your lordships has the discretion, my lords. I will pay, my lords, if your lordships directs. But my lords, let it be, my lords, not to cause undue hardship to the appellant, my lords. That is all.
Have you mentioned anything in the stay petition
Insofar as, my lords.
relating to your financial constraint?
Unfortunately not, my lords. That is there. I am in your lordship's hand, my lords.
That will be 20 lakhs. 50% will be 20 lakhs. 15% will be?
My lords, if I may just somewhere around, my lords, me 8 lakhs or so, my lords.
That will be too less an amount.
My lords, 10 lakhs, if your lordships. 10 lakhs is, my lords, 25, somewhere around 25% or so.
This is 54 lakhs we are
54
talking
lakhs.
about.
Yes, yes.
Let's see.
Yes,
We'll start with the dictation.
my lords.
So item number 10. Learned Counsel Mr. Jordan
Correct, my lords.
is present on behalf of the applicant stroke appellant. An appeal has been preferred by the appellant. Sri, it will be the BHE, no?
Yes, yes.
Not Sri, huh? By the appellant Dr. R. Lal
Thamona.
La Muana, comma, proprietor, he is a proprietor
Yes, yes.
of BHE, challenging the judgment and order dated,
27th August 2024.
passed by the learned
Senior Civil
Senior-
Judge.
learned civil judge, senior division 2,
2.
Aizawl district, Mizoram. Aizawl district, comma, Aizawl, Mizoram. Whereby and whereunder the appellant stroke applicant was directed to
I was directed to pay rupees 54.
around, this is rounded up to 54, no? Only
My lords,
54 lakhs? Or
my lords may, can my lords specify? There's no issue, my lords. 54, 58, 46.
plus 3 plus 54, comma, 58, comma, 465,
Yes.
comma, which is the decretal amount. The suit has been decreed in favor of the respondent with costs. It is submitted on behalf of the appellant stroke applicant that the learned trial court has erred by deciding this case without proper evidence, full stop. It has been, this suit is brought up with allegations that the plaintiff had engaged the defendant had engaged,
Yes.
the defendant had engaged the plaintiff as a subcontractor, whereas on the contrary, there was no agreement between both the parties to complete the contract work by the plaintiff as a subcontractor. Full stop. It is admitted by the plaintiff that he had paid rupees 1,40,000.
My lords.
1 crore 40 lakhs.
1 crore, 1,50,000 paid by the defendant, my lords.
1
the
crore
appellant.
1,50,000 to the plaintiff for
For-
expenses.
As expenses, come
As-
salary.
As expenses of the contract works, as both are related,
My lords.
as both the plaintiff and the defendant are related.
No, my lords.
not related
Purely
also.
contractual.
As expenses of the contract work, as he was helping him
Yes, yes.
with his contract work, without any written agreement or without any bills or any documentary evidence, this suit has been decreed in favor of the plaintiff. The learned counsel for the applicant has drawn the attention of this court to the judgment of the learned trial court, wherein issue number 4 was decided without proper documentary evidence by relying on the decision of this court in the case of
Yes, my lords. This is
Teshi Shelley versus Tayum Ete, decided on 22/3/2006, wherein it has been observed by this court that it is preponderance of probability that it is preponderance of probability of the case of both the contesting parties that should be taken into consideration. That from it is to consideration, you write in italics, type in italics. It is submitted on behalf of the applicant that even on the touchstone of preponderance of probabilities, the evidence has to be adduced in the form of documents to prove that that there was a subcontract between both the parties, which is the root of this case. It is further submitted that if interim stay is not granted, the appeal will be rendered infructuous, and the learned counsel for the appellant has prayed for interim for stay of the proceedings. If stay is not granted, not interim stay, stay of the proceedings of the civil, stay of the operation of the order, judgment and decree of civil suit number 30 of 2020. It appears that there is a prima facie case to grant stay. However, the petitioner is directed to pay 10%, 20%, it will be 25%.
my lords. 15% comes to around 8 lakhs.
8 lakhs.
10 lakhs comes 10% comes around to 5.4, 5.5.
15%, so 20%.
My lords, may kindly, my lords, if your lordships, my lords, I can't escape the fate, my lords, if the decree is executed anyway. On top of that, the appeal.
To 15%, to pay 15% of the decretal amount. It is submitted by the learned counsel for the petitioner, applicant, that the applicant is under financial constraints, and he has a good, and there is every possibility that his appeal will succeed. considering the submission of the applicant, the operation of the decree and order of civil suit number 2020, decree and order dated, what is the date?
My lords, this is 27th August 2024.
Of civil suit number 30 of 2020 is stayed until further orders. Issue notice to the respondent through registered post with AD as well as through usual process. A state till the next date, till the next date of listing is stayed till the next operation of the so and so is stayed till the next date of listing. Issue notice to the respondent through registered post with AD as well as usual process returnable within 4 weeks. In this appeal also, now in this appeal you can write down learned counsel Mr. Jordan
Yes, my lords.
is present on behalf of the appellant. Issue notice to the,
Respondent.
I think you can club this together, I think. No, but we'll dispose of this.
Yes, yes.
So don't club it together. Issue notice to the respondent through registered post with AD as well as through usual process. In this application,
Yes.
IA, please don't write issue notice. You come back to the appeal and there you write issue notice to the. In this IA, you just write the last sentence. In terms of the above order, IA stands disposed of. Okay? Or should it stay?
My lords, the stay, my lords, may be till the disposal
Till the
of
next
the appeal.
date.
Because
Till the
my lords is
disposal.
disposing of the IA.
No, let them come and pass an objection, submit an objection. Let them come and submit an objection.
As my lords read.
Till the next date of listing. State till the next date of listing, issue notice to the respondent through registered post with AD as well as through usual process returnable within 4 weeks. Now you come to this appeal. Learned counsel Mr. Jordan is present on behalf of the appellant. Issue notice to the respondent through registered post with AD as well as through usual process returnable within 4 weeks. Call for the trial court records of civil suit number 30 of 2020. List accordingly.
Grateful, my lords.
Item number 11.
Your Lordship, I'm for the respondent number 4 in this matter, and this is the second time listing. So I may pray for further 2 weeks' time to file affidavit in opposition, my Lord.
Affidavit in opposition.
Yes.
Similar prayer for respondent number 1 to 3.
Okay. Yes. What about you?
Yeah, one for the petitioner. Yeah.
Learned counsel Mr. A.R. Malhotra is present on behalf of the petitioner. Learned counsel Mr. B. Lal Ramenga is present for respondent number 4.
Number 4, my Lord.
Learned counsel Miss
Zaire himself believes.
is present on behalf of respondent number 1, 2, and 3.
Yes, ma'am.
We have 4 respondents only.
Yes, ma'am.
The learned counsel for the respondents have submitted for 2 weeks time to submit their
2 weeks, my Lord,
3
please.
weeks time to submit their affidavit in opposition.
Yes.
List accordingly.
Much obliged.
For orders, item number 12.
Worship, the matter may kindly be listed for hearing. We have received the paper book.
You
recently.
have received a paper book.
Yes. The matter can be listed for hearing.
All the parties are present.
Yes. Yes.
Learned counsel Mr. A.R. Malhotra is present on behalf of the appellant. Learned counsel Mr.
PC Lalthamoya. PC Lalthamoya.
P.C. Lalthamia is present for the respondent number 4.
Number 4.
Learned counsel Miss. Anybody present for respondent number PP? Respondent number 4 is the private respondent.
Yes, ma'am.
PP is present for the respondent state only.
Yes, ma'am.
Who is 2 and 3 then? This from the jail?
No, yes.
2 and 3.
1 and 2 khatam bani karo.
This is the paper book, no?
Yes.
Where is the appeal memo? This is the appeal memo. Oh, this is the appeal memo. This is the appeal memo, no?
Your Worship, 1 and 2 are the state. In fact, respondent number 2 is the person who, the case IO, complainant.
So people will be present?
Yes.
Huh? For 1 and 2? 1, 2 and 3, I think. Learned additional PP, Miss Linda is present on behalf of the respondent state as well as respondent number, as well as the other respondents. Okay. Paper book is ready. List the matter. Admit, right? Admit. List the matter for hearing. List the matter for hearing in the usual process or?
In the usual process.
Usual process. List the matter for hearing in the usual process.
Item number 15.
My lord, the petitioner was arrested on 5/2/2023 and in connection with the seizure of 404 grams of
This is at
heroin.
the, you have the CD?
This has come up for the first time.
This is the
first
first
time?
time, my lord, yes.
Okay, he was arrested and this is, investigation is going or charge sheet has been
Yes,
submitted?
trial is almost finished, my lord. Only one prosecution witness is being left.
Okay, then we'll have to call for the scan copies of the CD.
Charge sheet on.
Charge sheet, I have already annexed the charge sheet and even the deposition before the court also, my lord.
Charge sheet and the depositions also?
Yes, my lord, I have annexed all those things.
Okay. Charge sheet, depositions. What about the 161 statements?
161 statement is also there, my lord.
Annexed.
Yes, my lord.
Is it sufficient or you want anything else?
No, my lord, I think that will be sufficient. We can get just instruction. Let it be fixed for another day so that we can get instructions.
Instructions.
My lord, if your lordship permits, if it may be taken up next week, anytime.
Yeah. So if you obtain instructions, we can call for the scan copies also of the LCR. Meanwhile, because these are scan copies, it will come through email. So we won't have much trouble also.
Yes. Not a problem.
So once I start this case, I will have to end it or somebody else can take it up.
My lord,
If I start this case, if I grant bail or if I reject it, then I will have to finish this matter, isn't it?
yes, ma'am.
Yeah, according to the Supreme Court's order.
Yes, ma'am.
Learned Counsel Mr.
Yes, my lord, Shriyata.
is present on behalf of the petitioner, and Learned Counsel Miss Linda is present for a respondent state. Call for the scan copies of the LCR along with the scan copies of the CD and the depositions of the witnesses recorded so far. Learned additional PP, Miss, not Learned Counsel, Learned additional PP. Learned additional PP has also submitted to obtain instructions relating to the status of dependency of the case. When do you want?
My lord, Thursday,
Thursday? Not on Thursday, except on Thursday, any other day except
any other
Thursday.
day, my lord, anytime.
Next week or
Next week, next
the
week.
week thereafter? Next week?
Yes, my lord.
Wednesday then?
Wednesday maybe DB.
Okay. Then Tuesday will be too early.
Okay, Tuesday, my lord.
Okay, Tuesday.
I'm obliged.
Item number 16.
May I please, Your Lordship? My Lord, this is an application for implement of one Mr. Rokung Atsungte, who purchased the landed property covered by LSC 52 of 1996 during the pendency of civil suit number 2 of 2009. So, my lord,
What about the other party? Name is not reflected. Oh, yes, reflected.
item
Yes.
16, my lord.
Yeah, can be implemented because the land was sold, but I'll have to hear the other party. As the other party is appearing,
Yes, my lord. Other party, they were here.
can be implemented. Why not? But the other party has to be present at least.
Look, for the state, I'm present, there are private respondent 1 and 2. I don't think they'll have any objection, my lord.
I don't think so. What about you?
No objection.
No objection. Can be implemented.
Yes.
This same land was sold, this land which is under sub judice in a case.
Yes, my lord.
The same land same plot of land was sold to a party
Yes,
during
my
the
lord.
pendency of the proceeding.
Yes.
Can be implemented. Okay then. Are you sure they won't have any objection?
I don't think so, my lord. I don't think they'll have objection.
Let them come, I think. As the names are reflected, I'm not. I'm really hesitant to pass an order without hearing anybody. As the names are reflected in the. For the state, I have already heard. She has no objection. It's okay. Fine.
Yes, my lord. It is.
So should we wait for today or should we wait for some other day? Should we fix it for some other day?
My lord, it is according to your lordship's.
We'll wait for some time. They may be in the court number 1. We'll wait for some time. If they do not turn up, maybe we'll fix it for the next week,
Yes, my lord.
next Monday. Then you can ask them to be present in the court next Monday. If they don't turn up, we'll wait for some time.
Yes, my lord.
Okay.
Item number 17.
Just the time. Partisan on represents 11:30. Not represented, no? Applicant stroke appellant is not represented. List the matter after 1 week. List the matter after 1 week.
For admission, item number 2.
Please, your lordship, my lord. The counsel for the respondent number 6. Yes, she's here.
Yes, my lord. In the last court date, I was asked to receive, obtain instructions from the DC. If your lordship grants me another 1 week time to obtain further instructions, my lord.
Okay. Last order you were asked to obtain instructions from the DC.
Yes, my lord.
Learned counsel, Mr.
Dalfagoma. I'm for the petitioners.
Okay. Is present on behalf of the
Petitioners.
petitioners. Learned counsel, Miss.
Ming.
Write down.
Caroline Kenung, my lord.
Is present on behalf of respondent number 1 and 2.
Respondent number 6, my lord.
Respondent number 6. And learned counsel, Miss. Respondent number 1 and 5. Is present on behalf of respondent number 1 to 5. 1 and 5. 1 and 5. Only 1 and 5. Okay. The learned counsel for the respondent number 6 has submitted for some time to obtain instructions from the DC
Yes, my lord.
relating to the compliance of order of this court.
Yes, my lord.
List the matter after 1 week.
Obliged.
Item number 16.
So we'll push it up for the next week then. If the private respondents are not present, we'll push it up for the next week. Name can be included, but Learned Counsel Miss
Rudal Watfili.
is present on behalf of the, you are the appellant,
Yes, my lord. Appellant.
behalf of the appellant, stroke applicant. The respondents are not represented. List the matter on 11th. On 11th. List the matter on 11th.
Obliged.
No, we'll finish it. We have a hearing now. Yeah, we'll finish it. Or in midway, I can go and take the break. I'll take a break at 11:45.
Hearing list, item number 1.
Lordship, may I interrupt, my lord? I'm
yes.
sorry. That this part 2, item number 5.
Part 2, item number
Part
5.
2, item number 5. My
Part
lord,
2 list. Where is the part 2 list? I do not have the part 2 list. Item number 5, yes?
yes, my lord. In fact, we both are ready, but however, they still have item number 1. So, my lord, this may be taken up on Monday because I
Monday.
have personal difficulties tomorrow.
Personal difficulties tomorrow.
So, if you can take up on Monday, my lord.
Monday, okay.
I have no object.
Learned Counsel, Mr.
I'll drink the law.
With the consent of the other side, has prayed for adjournment. List the matter on Monday. Monday, what's the date on 11th? Okay. On 11th.
Bless
yes.
Excuse me, Lord, no.
I don't have the part 2 list.
I'll think.
This is not the part 2 list.
Lordship, if I may have your indulgence, item number 4, part 2.
Part 2, item number 4. Yes.
Yes, if it may be taken up next week with the consent of the counsel for the appellants.
Yes, yes. What's your name?
Item 6, your lordship.
Jonathan.
Jonathan.
Item 6.
Yes, your lordship.
Learned Counsel, Mr. Jonathan, with the consent of the other side. Learned Counsel for the respondent, no?
I'm for the respondent, yes.
One respondent or two?
One respondent.
Sole respondent.
Sole respondent.
For the sole respondent, with the consent of the other side, has prayed for adjournment. Learned Counsel, Mr. A.R. Malhotra is present on behalf of the. This is an appeal or a
Yes, your
petition?
lordship.
Appellant is present. List the matter when do you want?
Next week.
Coming week?
Coming week.
Yes.
Coming week, 11, 12, 12. Hope it's not a Wednesday, 12. 12.
12.
Obliged. Lordship. Item number 1.
May it please your worship. This is a first appeal against the judgment and order passed by the trial court dated 20th of October 2021 in money suit number 70 of 2011. Your worship, the present appellant was the respondent number 1 and the respondent number 1 was the plaintiff before the trial court, Your Worship. While the state were defendants number 2 and 3 before the trial court. And Your Worship, the basic case of the plaintiff respondent number 1 was that due to the construction made by the defendant number 1, the present appellant, which is on the lower side of his land, there were cracks which appeared in his land, the plaintiff's land, and there were cracks in his Assam type building, due to which there was danger of his house collapsing. So he submitted a complaint to the deputy commissioner, and accordingly, verification was done by the concerned authorities. And there was a report stating that it was due to the fault of the construction taken by the defendant number 1. And I was directed to construct a retaining wall so that there won't be any collapse of the house. But anyway, the district deputy commissioner had directed that the house of the plaintiff should be dismantled. And accordingly, evaluation was done by the state defendants. And the valuation came to about 12 lakhs. which the trial court had relied upon for granting the compensation to the plaintiff. And another subhead was the grant of compensation for mental agony. And third was for loss of income. So accordingly, if I may take a lordship to page 178 of the paper book.
Yes.
Paragraph 22, the trial court had framed 7 issues altogether. As your lordship, paragraph 22, page 178.
Yes.
So all
Issues, yes.
all I'll take your lordship to the discussion regarding issue number 6.
Just a moment. You can call them later because this will take some time, so not required. Yes.
Yeah, issue number 6, the discussion by the trial court starts from page 203. The discussion regarding issue number 6 starts from page number 203, Your Lordship.
Issue number 1, no?
Yeah, Your Lordship, yes, issue altogether at page 78, page 178, altogether 7 issues were framed.
7 issues were framed.
Yes. So I'm concerned with issue number 6, Your Lordship, whether the sum type of the plaintiff has been properly valued for the purpose of claiming damages against the defendant number 1. And the discussion regarding issue number 6 is at page 203.
All right.
So if I may take a lordship to page 203, the discussion regarding issue number 6.
Yes.
If I may read from paragraph 75. If I may, Lordship?
Paragraph 75, yes.
Yes. This is regarding issue number 6. Whether the sum type of the plaintiff has been properly valued for the purpose of claiming damages against the defendant number 1. Para 75.
Yes.
Regarding this issue, the plaintiff state on his pleading that on the requisition of the Deputy Commissioner, Aizawl District, White letter number so-and-so dated 4/4/2011, building valuation of the house building belonging to the plaintiff was prepared by the estate officer PWD and the executive engineer Aizawl Building Division before the said house building was dismantled. As such, the value of the Assam type building belonging to the plaintiff is rupees 12,53,300 only, and a copy of which was furnished to the plaintiff by memo number so-and-so dated 11/4/2011 for further necessary action. On the other hand, the defendant number 1 submits on his written statement that the assessment valuation of the Assam house building of the plaintiff by the said engineer appears to be not based upon facts but on the information given by the plaintiff. The total valuation given by the officer concerned as 12,53,300 cannot be accepted in view of the fact that the said Assam type building of the plaintiff was in a dilapidated condition even before the said incident. Before dismantling the said building, the defendant number 1 frequently visited the said house and had even taken photos of the same. A glance over the said photos will clearly indicate that even as on the prevailing market rate, the said house building will not have a value of more than 3 lakhs. In this connection, it may be further stated that the defendant number 1, with the help of an engineer, had thoroughly examined and evaluated the said Assam type house building of the plaintiff, and it was found that the total value of the said building as the year of construction, that is 2004, and came to rupees 2,70,110, out of which depreciation for 7 years, that is 92,140, if deducted, would come to 1,79,893. Thus, the building valuation prepared at the instance of the plaintiff being based on presumption and surmises, the same cannot be relied upon for the purpose of claiming damages. In fact, the plaintiff is liable to be prosecuted for making false claim in respect of the said building. Here, as per the direction of the Guwahati High Court Aizawl Bench, the author of Exhibit P13, that is building valuation in favor of P.C. Lalrinoma's building, that is the plaintiff's building at Edenthar, Wing, Aizawl, were called as court witnesses number 1 and 2. Both witnesses stated that even though they did not go and visit the building of the plaintiff, the valuation of the building of the plaintiff was done as per government rate prevailing at the time. Here, other than their pleadings, both sides do not have much evidence to be based upon. But the difference of their submissions is that the plaintiff exhibited the assessment prepared by the estate officer and the executive engineer, PWD Aizawl Building Division, as Exhibit P3. After comparing with the original and as per direction of the High Court, the author of Exhibit P13 were also called as witnesses for examination before this court, and the court witness were also examined by the defendant, were also cross-examined by the defendant number 1. However, the defendant number 1 did not exhibit or compare his assessment based by him in his written statement. Further, on careful perusal of the assessment report itself, it is learned that the assessment submitted by the plaintiff is prepared by proper channel or as per requisition made by the Deputy Commissioner, Aizawl, and the same was prepared after conducting duly spot verification only. It is also seen that the building valuation of the plaintiff was also done using government rates prevailing at the time of assessment. Therefore, considering both sides' submission and on careful perusal of the assessment enclosed by the plaintiff, the court has no other option to rely upon other than the assessment prepared by the PWD official on requisition of Deputy Commissioner Aizawl. And if the court did not rely upon the said assessment, there can be no chance to reassess the value of the plaintiff or subtype building, as the same has already been dismantled. Further, the PWD are the expert authority for assessing value of land and building, and their assessment should be reliable enough. Hence, it is decided that the plaintiff or subtype building has been properly valued for the purpose of claiming damages against the defendant number 1. So, Your Worship, the trial court has relied upon the assessment made by the PWD, which is Exhibit P13. But according to this, the assessment which is Exhibit P13, if I may take your Lordship to Exhibit P13, it is at page 29. It starts from page 29, Your Worship, Exhibit P13.
Yes, on page 29, yes.
Yes, this is from the Office of the DC forwarding the assessment to the plaintiff, page 29. Page 30 is the valuation, the first page, and Your Worship will see page 31. This building valuation was made by 2 officers, bottom of the page, the estate officer PWD and the executive engineer PWD.
Yes.
And page 32 is the valuation calculation at page 32.
Yes.
And it is signed by both the estate officer as well as the executive engineer. So, with regard to this, Your Worship, they were both called as court witnesses. And if I may take your Lordship to the statement recorded by the court regarding the evidence given by the court witnesses, which is at page 195. I'll read from para 57, page 195.
Yes.
Page 195. I'll read from para 57 onwards here.
Para 57 onwards.
Onwards. As directed by the Guwahati High Court Aizawl bench in order dated 30th of September 2019, passed in cross objection number 2 of 19 in RFA 5 of 2019. This case is re-endorsed to this court for trial and disposal from plaintiff evidence stage. The case record was received on 3rd February 2020. Also seen Wakalatnama executed by the plaintiff in favor of so and so. On 30th of February 2020, summons was issued to Estate Officer PWD Estate Officer Aizawl Building Division and Executive Engineer PWD Aizawl Building Division Aizawl. But due to COVID-19, the said witnesses were examined and cross-examined only on 22nd February 2021 as court witnesses. Para 58, this is the first witness. His name is Tlang Ming Thanga. The court witness stated that he retired from service in the year 2013. He stated that he was posted as Executive Engineer PWD Aizawl Building Division from the year 2009 and building valuation in favor of Mr. P.C. Lalrinoma's building at Edenthar, Weighing Aizawl, within LSC number 2008 of 1987, was forwarded to him by his subordinate officer for approval. It was also stated that the building valuation in favor of Mr. P.C. Lalrinoma's building at Edenthar, Weighing Aizawl, within LSC number 2008 of 1987 was done as per relevant government rate prevailing at that time. On cross-examination by the defendant, the witness did not deny that the valuation of the building belonging to the plaintiff was not done by him and that he did not go and see the building belonging to the plaintiff before and after he put his signature in the valuation report. The witness denied that the assessment was not done as per the relevant government rate prevailing at that time. So it's a clear admission by this witness. He did not visit the building. He did not see the building belonging to the plaintiff before and after he put his signature in the valuation report. So valuation was not done by him. Para 60, Yaship, this is the court business number 2.
Yes.
The para 60, the court witness number 2 stated that she was posted as Estate Officer PWD, Estate Office, Aizawl Building Division from the year 2008 to 2011. That as per requisition made by DC Aizawl, valuation of P. Lalrinoma's building at Edenthar Weighing within LSC number 2008 of 1987 was assessed and prepared by the draftsman. Has your lordship got? She had perused the assessment prepared by the draftsman and that assessment was done as per relevant government rate prevailing at that time. The witness stated that she submitted her signature to the valuation report and thereafter forwarded the same to her superior officer for approval. On cross-examination, the court witness number 2 did not deny that the valuation report of the building belonging to the plaintiff was assessed and prepared by the draftsman and not by him. The witness admitted that she did not go and visit the building belonging to the plaintiff to verify assessment prepared by the government. However, the witness denied that the assessment was not done as per relevant government rate. So, Your Worship, both the court witnesses, the executive engineer concerned and the estate officer concerned have admitted in their cross-examination assessment was not made by them.
Yes.
They just put their signature,
Yes,
assessment was made by the draftsman. So how could the trial court have based the relief of granting the value of the Assam type building?
Could not help it, I think, because the building was already dismantled.
Yes. But these two persons who have stated that they have made the assessment of the Assam type building, they were not the
They
persons.
did not go and see the building.
The draftsman who had made the assessment.
They have just affixed their
Yes.
signatures.
So their evidence has no probative value, Your Worship. It has no value at all because the assessment report, which says that the value of the building was 12 lakhs plus, it was not made by them. So the draftsmen who had prepared the assessment report were never produced by the plaintiff as his witnesses or even called as court witnesses. So the onus of proof is on the plaintiff to prove that the value of his building is 12 lakhs 33,000. When the plaintiff is relying on the assessment report, onus of of proof is on him to prove that the valuation is done in accordance with law and it is proper and the value of the building is 12,53,300. But my humble submission, Your Lordship, is that he has failed to prove the assessment report as per law. Because although the signatories to the assessment report, Exhibit P13, were produced as court witnesses, but they have admitted that they did not do the valuation. It was done by some other draftsman. They have not even given the names of the draftsmen, and nor have they been produced as a witness. So the trial court could not have relied on Exhibit P13 to come to a finding that the value of the building of the plaintiff was in fact 12 lakhs 53,300. And in fact, with regard to Your Lordship, Exhibit P13, if Your Lordship will see page 32.
Yeah, I've seen.
Regarding the area also, Your Lordship.
Regarding the area.
Yes.
Yes, regarding the area.
I'll just one. If Your Lordship will see page 32,
Yes.
Building valuation in favor of PC Lalrinoma's building. If Your Lordship will see ground floor, plinth area of the building, ground floor, Your Lordship will see 56.46 square meter.
Yes.
Ground floor is 56.46 square meter. Then first basement, according to them, is 44.48 square meter. And second basement is 26.10 square meter.
Is this a two-storied building?
That is, Your Lordship, I'm coming to that. So according to them, the total area of the building comes to, if Your Lordship will see page 233, ground number 5.
233.
No, if Your Lordship will kindly go to page 233.
33.
Page 233.
233, okay.
Ground number 5 of my appeal. Page 233.
Yes, ground number 5.
Further, a plain reading of joint inspection report, which is Exhibit P10, shows that the total area of the Assam type building belonging to the plaintiff respondent number 1 is 30 feet into 21 feet, equals to 630 square feet. If we go to Exhibit P10, and the total area of the 3 floors, whereas as per the building valuation, which is Exhibit P13, the total area of the 3 floors of the Assam type building is 56.46 square meter plus 44.48 square meter plus 26.10 square meter, totaling 227.04 square meter. Hence, it is clear that there is a vast difference in total area of the Assam type building between Exhibit P10 and P13, which means that the assessment of the Assam type building as per Exhibit P13 is unreliable. So, I'll take Your Lordship to Exhibit P10 and P13. Page 32 is P13, which where the area has been added up to 127.04 square meter. Page 32. Now, if we compare it to Exhibit P10.
So this is an Assam type building.
Yes.
P10.
Exhibit P10 is at page 23.
Yes.
This is joint inspection report, which was conducted by the authorities in the presence of all the parties. If I may read, Your Worship. As per letter number so-and-so, dated 25/3/2011, issued by the Additional Deputy Commissioner, Aizawl, a joint inspection was conducted on 25th of March 2011 by the undermentioned person in respect of damage likely to be caused to the house building of so-and-so and others by the proposed construction and site preparation of land of Shri C. Lal Tanpuya of Chandmari on the site of National Highway 54. So altogether 5 officers were present. Serial number 6 is the plaintiff. So serial number 6 is the defendant number 1, present appellant, and number 7 is the plaintiff. If your lordship will see, the site preparation for construction of Godown dwellings house by Shri C. Lal Tanpuya of Chandmari on the upper side of National Highway 54 at Edinthar Way is likely to cause damage on the building of Shri P.C. Lal Rinoma of Chandmari West. That is Assam type building standing along the PWD road from Chandmari to Edinthar and the PWD road from Edinthar to Chandmari and to others. The following is their finding recorded by the team. Number 1, the cracks caused by the house site development, preparation of C. Lal Tanpuya has made the Assam type building belonging to P.C. Lal Rinoma, which measures 30 feet into 21 feet. So the joint inspection report says the area of the Assam type building is 30 feet into 21 feet. That comes to your worship 630 square feet. Now, if we go back to the area has gone up to 127.04 square meters. How is the plaintiff going to explain the difference in this area? In fact, 127.04 square feet. So, from 630 square feet in the joint inspection report, in the building valuation report, it has doubled, more than doubled. How could so it is clear that the Exhibit P13 is unreliable, because the plaintiff's own documents show that the area of the Assam type building between Exhibit P10 and Exhibit P13 is very different.
So according to you, P13 is unreliable.
Yes, evaluation report is unreliable. It cannot be relied upon. And according to page 32, the Exhibit P13, it says that there are 3 floors: ground floor, first basement, second basement. But now even this is also controversial. If I may take your lordship to page 22. So it starts from page 21.
Yes.
This is the geotechnical assessment report, Exhibit P9. At page 22.
Page 22.
Yes. Recommendations and suggestions. Your lordship will see serial number 1. P.C. Lal Rinoma house of 2-story should be dismantled. Here it says 2-story. Exhibit P13 says it's 3 stories. So even if I take your lordship to the statement of PW number 3, PW number 3 is at page 126. From page 125. PW number 3.
So there's a controversy here.
Yes.
So sometimes roof will be like this.
Yes.
So again, if it is either 2-story or 3-story, whatever it is,
Yes.
if the roof is flat, then we can consider as a 3rd floor also, which has not been constructed.
Yes.
But now we have an Assam type building, so there is confusion.
Yes. Yes. So if your lordship will see
Page 125, yes.
this is examination of in chief of PW number 3 H. Lal Biakima. He was the geologist junior.
Yes.
Para 6, your lordship. If I may read, page 126. That in our said house site geotechnical assessment report, recommendations and suggestions have been made by us and submitted our report to the concerned authority. Accordingly, the house of two-story building belonging to PC Lalrinoma had to be dismantled. So again here,
2 stories.
2 stories. So how could the Exhibit P13 valuation report say that it was consisting of 3 floors? So in spite of all this, Your Worship, the trial court had relied upon the assessment report
All right.
to hold that the value of the Assam type building was 12,53,300. And regarding that, Your Worship, that is why issue number 6, we have challenged the finding of the trial court regarding issue number 6. And in the relief granted by the trial court, the value of the Assam type building as per Exhibit P13 was granted to the plaintiff. My humble submission, Your Worship, is that Exhibit P13 could not have been relied upon for making valuation of the Assam type building of the plaintiff. The alleged authors, court witnesses, they admitted that they had not prepared the valuation report. It was prepared by the draftsmen who were not produced. Then there is controversy regarding whether it is a 2-storied building or 3-storied building. So all that was not considered by the trial court. The trial court just held that since it is a government document and it has been exhibited, so I have to rely on that. But
Yes.
onus of proof is on the plaintiff to prove that these documents were prepared as per law and it has probative value. Regarding that, Your Worship, I would like to rely on
Yes.
I'll take your worship to page 496, para 25,
Yes.
para 25, page 496,
Yes.
if I may read.
Yes, please.
We are of the firm opinion that mere marking of exhibit on a document, which is required to be done in accordance with law, at the para 31, Your Worship, para 31, page 497. Under the law, necessary that contents of documents are required to be proved either by primary or by secondary evidence, but not its truth. Documents having not been produced and document cannot be proved by merely filing. Contents have to be proved whenever produced, relied upon by the trial court. One more judgment, 2011 4
You give me a printout of this case. Printout, if possible. Printout of this judgment. No, later. After conclusion.
2011
Yeah, I agree.
2011 4 SCC 240. I'll read from para 14, Your Worship, page 245.
Para 14.
Yes, page 245. I'll read para 14 to 17.
Yes.
Para 14 at page 245.
Yes, yes.
In our humble opinion, the trial court could not proceed in such an unwarranted manner for the reason that the respondent had merely admitted his signature on the photocopy of the power of attorney and did not admit the contents thereof. More so, the court should have borne in mind that admissibility of a document or contents thereof may not necessarily lead to drawing any inference unless the contents thereof have some probative value. These two aspects cannot be combined. A document may be admissible and yet may not carry any conviction and weight, or its probative value may be nil. So here also, Your Worship, they have admitted they've proved the document by bringing the author, but it has no value because the author himself has admitted that valuation was done by the draftsman. It was not done by us. So it has no value, Your Worship. In para 16, in Madan Mohan Singh versus Rajni Khan, this court examined a case as a court of fifth instance. The statutory authorities and the High Court had determined the issues taking into consideration a large number of documents, including electoral rolls and school leaving certificates, and held that such documents were admissible in evidence. This court examined the documents and contents thereof and reached the conclusion that if the contents of the said arithmetical exercise, it would lead not only to improbabilities and impossibilities but also to absurdity. This court examined the probative value of the contents of the said documents and came to the conclusion that Srimati Shakuntala, second wife of the father of the contesting parties therein, had given birth to the first child 2 years prior to her own birth. The second child was born when she was 6 years of age. The third child was born at the age of 8 years. The fourth child was born at the age of 10 years. And she gave birth to the fifth child when she was 12 years of age. Para 17. Therefore, it is the duty of the court to examine whether the documents produced in the court or contents thereof have any probative value.
Yes. So I'll just stretch my legs and come back
Yes.
in 5 minutes.
Okay.
This judgment also.
It's on TV. Yeah. Break. Lah.
Kaum niya oh. Ngay chat. Kasi nuteka pesa usa udo na chuban no tehi mida kanom sila mo. Chuban sa karo inland do lo niya. Kan te pek lain karon lang do male ay ka hat. Pumari na kha trang ulan ni ka. Sarkar document bo kan ni kay transan vek sel sarkar DC assessment compensation
May I take your lordship to page 233 of the Memorandum of Appeal, ground number 6.
Yes.
If I may read from ground number 6, your lordship, 6 and 7.
223, no?
233.
233.
233.
Yes.
Further, the trial court, in para number 82 of the impugned judgment and order dated 20th of October 2021, while deciding issue number 7, had illegally directed the appellant to pay rupees 2,44,000 as damages on account of mental suffering, agony, inconveniences, and loss to the plaintiff respondent number 1. In fact, a plain reading of the plaint reveals that the plaintiff respondent number 1 has nowhere pleaded that he had suffered mental suffering, agony, inconvenience, and loss due to the actions of the appellant, and nor has he explained in what manner he had suffered mental suffering, agony, inconvenience, and loss. Further, the plaintiff respondent number 1 has not adduced any evidence to prove that he had suffered mental suffering, agony, inconvenience, and loss due to the actions of the appellant. Hence, the decision of the trial court directing the appellant to pay rupees 2,44,000 as damages on account of mental suffering, agony, inconvenience, and loss is unsustainable in law. Further, the trial court, ground number 7, in para 82 of the impugned judgment, order dated 2010 to 2020, while deciding issue number 7, had illegally directed the appellant to pay 2,44,000 as damages on account of mental suffering. In this regard, it is submitted that the trial court has based its calculation of fixing the value of rupees 2,000 per month as the rate of inflation of rent, which the plaintiff respondent number 1 would have received over the course of 10 years on assumption and not on evidence on record. The trial court cannot base its findings on assumption, and it has to base its findings on evidence on record. So if I may take your lordship to para 82 of the judgment, which is at page 206.
Quite a long judgment.
Yes, Your. Yeah, because the trial court has enclosed all the evidence of all the witnesses. That has made it a bit lengthy. Page 200, it starts from page 205. Your lordship, we kindly go to page 205.
Yes.
Issue number 7, whether the plaintiff is entitled to the reliefs claimed, if so, to what extent. So, at page 206, Your Lordship, para 81 is regarding the valuation of the Assam type building. Page 82, Your Lordship. Para 82. If I may read para 82.
Yes, please.
The plaintiff in paragraph 17b of the plaint also claimed compensation amounting to 5 lakhs on account of mental suffering, agony, inconveniences, and loss and costs of the suit. It is seen that the plaintiff has been forced run around every different government office due to the action of defendant number 1. In the end, the plaintiff had to dismantle his house due to actions of defendant number 1. Even if the plaintiff has possession of his land, he has been deprived of peaceful enjoyment of his land. If not for the actions of the defendant number 1, there is every possibility that the plaintiff would receive a rent higher rate than rupees 3,500 per month, which he was receiving in 2011 due to inflation and increase in demand for house dwelling in Aizawl city. Keeping this in mind, it is fair to assume that there would have been an increase in the rent receivable by the plaintiff. It is also seen that this case has been pending for 10 years since it was filed on 15/7/2011. Even if it is not possible to arrive at a fixed figure of inflation, some guesswork can be utilized, and this court thinks it fit and proper to quantify and fix the value of rupees 2,000 per month as the rate of inflation of rent that the plaintiff would have received over the course of 10 years, or the amount of money that the plaintiff has been deprived of due to action of the defendant number 1, and multiply the amount with the number of months that the plaintiff would have received rent during the pendency of this suit. Accordingly, the defendant number 1 is directed to pay rupees 2,44,000 from 15/7/2011, that is date of filing the suit, till 17/9/2021, or 122 months multiplied by rupees 2,000 as damages on account of mental suffering, agony, inconvenience, and loss and cost of suit amounting to rupees 5,000 is granted. That is the amount of court fees. So, Your Worship, the trial court has awarded the plaintiff 2,44,000 as damages on account of mental suffering, agony, inconvenience, and loss. So, but there, with regard to this, Your Worship, there is no pleading in the plaint, and there's no evidence adduced by the plaintiff regarding the mental agony suffered by him, inconvenience suffered by him, loss suffered by him. Nothing. There's nothing on evidence as well as in the pleading, except, if I may take Your Lordship to the plaint, page 8
Page 8 of the paper.
of the paper book. This is para 17. Para 17, page 8, para 17, Your Worship.
Yes.
This is the reliefs claimed by the plaintiff. Subclause B. Let the decree be passed in favor of the plaintiff and against the defendants to pay rupees 5 lakhs as compensation on account of mental suffering, agony, inconvenience, and loss and cost of the suit. So, in the relief claimed by the plaintiff, he has claimed rupees 5 lakhs as compensation on account of mental suffering, agony. But there's nothing in the pleadings. If Your Lordship will see from para 1 to para 16, there no pleading as to what was the mental suffering caused to him, what was the agony, inconvenience, nothing of that sort in the pleadings. Only in the prayer portion he has claimed 5 lakhs on account of mental suffering and pleading. And this, if Your Lordship will see para 82 of the judgment, the trial court has gone on presumption that the rate of inflation will be 2,000 per month. It's all based on presumption, Your Worship. And regarding this, Your Worship, I would like to rely on 2003-4 SCC 161.
Print out of the judgment also. Yes, 161.
Para 7, Your Worship,
Parasol.
at page 165. As regards the plea of subtenancy argued on behalf of the defendants by the learned counsel, first we may note that this plea was never taken in the written statement the way it has been put forth now. The written statement is totally vague and lacking in material particulars on this aspect. There is nothing to support this plea except some alleged revenue entries. It is settled law that in absence of a plea, no amount of evidence let in relation thereto can be looked into. Therefore, in absence of a clear plea regarding subtenancy, the defendants cannot be allowed to build up a case of subtenancy. Had the defendants taken such a plea, it would have found place as an issue in the suit. We have perused the issues framed in the suit. There is no issue on this point. So even in our case, no issue regarding this was framed by the trial court. Plus, there is no evidence regarding suffering of mental suffering, agony, etc. Even there is no pleading to that effect. Only that in the relief claimed by the plaintiff, he has claimed rupees 5 lakhs on account of mental suffering, agony, etc. But there's no pleading in the plaint. There's no evidence adduced by him. So, and para 82 of the judgment, the trial court has gone on presumption inflation will be this much per month, and he has granted 2 lakhs 44,000 on account of mental agony. So this relief of 2 lakhs 44,000 also has no basis. The trial court cannot have granted this because there is no pleading to this effect, no evidence also to this effect. And lastly, Your Worship will see if I may take Your Worship to page 235 of the Memorandum of Appeal.
In the paper book?
Yes, yes, 235 of the paper book. If I may read, page 235,
Yes.
ground number 8.
Ground number 8, yes.
Further, the trial court, in para number 84 of the impugned judgment and order, dated 2010-2021, while deciding issue number 7, had illegally directed the appellant to pay rupees 4,27,000 as a loss of income to the plaintiff respondent. The trial court has calculated the loss of income on the basis of monthly rent of rupees 3,500, which used to be collected by the plaintiff respondent from the defendant from the date of filing of the suit, that is 15/7/2011 till 17/9/2021, or 122 months into 3,500 per month. In this regard, it is submitted that the trial court could not have calculated the loss of income by multiplying the rent collected by the plaintiff respondent number 1, that is 3,500 into 122 months, as there is no certainty that the plaintiff respondent would have continued to collect the rent for 122 months. Ground number 9, Your Worship. For that, a plain reading of deposition of BW number 4, Reng Kuma Tsatswag, and BW number 3, Ning Tansangi, shows that they were tenants of the plaintiff respondent number 1, and all 3 tenants had vacated their tenanted premises in March 2011. In fact, DW number 3, Ming Tansangi, had deposed that she had vacated the tenanted premises in the middle of March 2011 due to personal reasons. As the plaintiff respondent number 1 had filed the suit on 15 July 2011, it is clear that on the date of filing the suit, the plaintiff respondent number 1 had no tenants, and he was not collecting 3,500 per month as rent from his tenants. Hence, the trial court could not have concluded that the plaintiff respondent number 1 had suffered loss of income, that is the amount of rent lost by the plaintiff respondent number 1. So, DW number 3, Your Lordship, she was one of his tenants.
Yes, yes.
And if I may take Your Lordship to her deposition, which is at page 144.
Yes.
Page 144. In fact, although she was a tenant of the plaintiff, she was one of the witnesses for the defendant number 1. So, I, Ming Tansangi, daughter of so-and-so, para 1. I used to occupy and rent the ground floor of the sub-type building of the plaintiff in the year 2008. And I continued to occupy the said building till March 2011 with a monthly rent of 800 per month. That during my period of occupation of the ground floor of the said building, there already existed several cracks on the bathroom floor, steps, and the corridor leading to the ground floor. In the month of February 2011, the defendant number 1 started developing the Sudan. However, due to this, there was no fresh or new cracks in the floor occupied by me, as far as my knowledge is concerned. Para 4. Due to personal reasons, I had vacated the said building in the middle of March 2011, and immediately thereafter I was married to my present husband, namely Lalwat Fella, with whom I am staying in Khatla at Aizawl. So, Your Worship, her evidence clearly stated that she had vacated the house of the plaintiff in the middle of March, not due to any construction work taken by the appellant, but because of her personal reasons. So, the trial court could not have come to a conclusion that the loss of rent from this tenant was due to construction, but she had left due to her own personal reasons. And in the cross-examination at page 146, Your Worship. If I may read her cross-examination at page 146.
So this plaintiff is defendant is the engineer.
No, Your Worship. Defendant number 1 is the
plaintiff suit was decreed in favor of the plaintiff.
Yes.
So it is the engineer.
No. Defendant is the property owner just below the plaintiff's land. So that is why,
You are
according
for
to
the defendant who is the appellant now.
yes, so if Your Lordship will see page 146, the cross-examination of the
Yes.
defendant's witness number 3. On 18 March 2011, I vacated my rented house owned by the plaintiff and other tenants like Mr. Ren Kumar, Mrs. Ma Biaki, 2 vacated the house on 18 March. While I was the tenant of the plaintiff's house, there was a crack on the bathroom floor, maybe as wide enough as the size of a little finger. In the steps, there also existed small and wide cracks as well. In the balcony, there's a crack on the cement. I do not know how deep the above-mentioned cracks exist below the ground. It is not a fact that the cracks exist in and around the plaintiff's house as a result of excavation work performed below by Mr. Laltan Puya. The excavated area and the plaintiff's house are in close proximity with each other. I have not revisited our rented house.
Because he was constructing the house, so these cracks had appeared. That is the allegation.
That is the allegation. But she says that there were cracks much
Early
before.
prior to that.
And according to her, she left the house due to her personal reasons, not due to the construction. And in a cross-examination also, the plaintiff did not even give a suggestion to her that you left the house because of the construction work, not because of your personal reasons. No suggestion, nothing. So there's no denial that she left the house due to her personal reasons and not because of the work done by the present appellant. So how could the trial court have come to the conclusion that the loss of the rent of this tenant was due to the construction work?
So he is only the owner of the house. The defendant is only the owner of the house.
The plaintiff.
He is who has constructed the. You are the defendant, isn't it?
Yes.
Excavation work.
Yes.
You have
Excavation.
started excavation work.
Below the land of the plaintiff.
Excavation work.
I'm the owner of that property.
You are the owner of the property. You are absolutely private party.
Neighbors, yes, we are neighbors.
But you are not engineer or any
Nothing.
party.
Neighbors, yes, we are neighbors.
But you are not engineer or any.
Nothing.
Not in official
No.
capacity.
So we are both landowners. My property is below the property of the plaintiff.
Excavation, you have started construction, not
Yes.
excavation.
Yeah, to construct the work, Your Worship, out here, because of the hilly area, terrain. So excavation of the
Also, you have
soil.
to find out whether the soil is
Yes.
will be supporting
Yes.
the house, and then also
Yes.
excavation has to be done.
Yes.
Prior to
So
constructing
according to the
anything.
plaintiff, due to the excavation work done by me for constructing the
Now
house.
I got the point because
Yes.
because you are suggesting excavation all the time.
Yes.
So I am wondering. construction
Excavation,
or-
excavation for construction of house.
every house to construct any house will have to.
It's on the hillside. So Your Worship,
You'll have to,
majority, say 80% of the houses, excavation has to be done.
Has to be done.
Because all the houses Your Worship will
Whether
see
it
is on
is
the
from-
hillside.
Yes, on the peak. I'm very surprised. On the peak.
Yes. So that is why majority of the houses, say 80% of the houses, to construct the house, you have to first excavate the soil.
To
on
find
the
out
hillside.
how firm the ground
Yes.
is because of the hilly
Yes.
terrain.
So the allegation of the plaintiff is that due to my construction work, excavation of soil, they develop cracks within his.
Yes,
some
that I
type.
understood.
Yes.
That much I understood.
So my humble submission, Your Worship, is that the trial court has the plaintiff towards the value of the Assam type house building. That also based on the exhibit P13, which was not proof. The persons who signed the valuation report were produced as court witnesses. They admitted they were not the persons who made the valuation. They were the draftsmen. Draftsmen were never produced.
And that I got your point.
Then regarding
Only one. And
Signet-
that I got your point.
then regarding
Only one thing was puzzling me: excavation. That
Yes,
excavation word that was puzzling me because we have never come across such
Yes.
excavation or
because in the plains you just
just construct the
yeah
house.
construct and put the pillar,
Yeah.
but here you have to cut the hillside.
So I was wondering whether he's in excavating in official capacity as a geologist or something like that, because you brought on geological report also.
Yes, right.
That is why I was wondering. Now it is clear.
Okay.
Once I've asked you the question,
Yes.
it's clear now.
So even the damages awarded by the trial court regarding mental agony, there's
I
nothing.
got your point,
nothing. Even
Without any pleadings,
yes. Loss of income also. The evidence produced by the present appellant shows that one of the tenants left because of her own
Yes,
will, not because of the construction
yeah,
work.
yes,
So
yes.
the
It has been ingrained
Yes.
in my brain.
so my humble submission,
Very
Your Worship,
nice, elaborate argument.
So
I
my-
remember all your points.
My
Don't
humble
worry.
submission, Your Worship, is that the trial court judgment is not sustainable.
Yes.
It is not based on evidence at all.
You have only 2 points.
Yes.
That issue number 6 and that mental agony.
Yes, issue 6 and 7.
compensation.
Issue 6 and 7.
Only against 2 points.
Yes, issue 6
That
and
is
7.
the main point.
That is the
Core-
main point.
That is the core of the case.
You know, I cannot challenge the finding of the trial court that the cracks developed because of my work. There's enough documentary evidence produced. But the quantum of damages awarded by the trial court is not based on evidence.
Yes, yes.
That is my.
Yes.
And Your Worship, at the time of admission, the present appellant was directed to deposit 4,50,000 for stay, which was deposited and withdrawn by the plaintiff.
Okay.
So that, and if your lordship will see, the order passed by the Honorable Court.
I'll need a copy of this judgment also. Order in the appeal, no?
Yes, order dated, Your Worship, 2nd of March 2022.
2nd of March 2022.
In the present appeal, the order sheet.
Yes.
So if your lordship will see this order, it shows that the 4,50,000 was deposited by the present appellant, and at para 5, para 5 and 6, Your Honor. In view of the above, let the appeal be admitted. Call for the LCR. No fresh notice is required to be issued to the respondents as they are duly represented by their respective counsels. The interim order passed on 20th of January 2022 shall continue until further orders. Liberty is granted to the respondent plaintiff withdraw the amount deposited by the appellant on proper identification and as per procedure prescribed in this regard, if so desired. It is, however, provided herein that withdrawal of the deposited amount would be without any prejudice to the respondent plaintiff to receive further amount as may be ultimately decided by this court. And similarly, the same will be without any prejudice for the appellant to get a refund of the said amount. So anyway, Your Worship, so accordingly, they have already withdrawn 4,50,000. So basically, that is the, Your Worship, the quantum which has been awarded by the trial court is not based on evidence, is not based on pleadings. The valuation report cannot be relied upon. Mental agony, inflation, presumption, everything. Your Worship, I don't know how the court came to that. And even loss of income, when the tenant has herself stated that I left the construction work of the appellant. So how could the trial court have held that loss of income is there from that?
Please, Your Lordship. My Lord, I am for the respondent plaintiff. As my learned friend, I believe his submission was on only 3 points regarding the contents of Exhibit P13, that is the building assessment. The second one being is that the damages was based on guesswork and not evidence.
Yes,
And
yes.
thirdly, I believe it was on the amount of loss of income. And his submission was that one of the tenants had stated that she left out of her own free will, not because of the
So
cracks.
that person had only one tenant.
No,
3 tenants.
Three tenants.
And Your Worship, the last point we took was all the tenants vacated the premises in March 2011.
Correct. I'll come to that, my lord. Why?
That you have stated according to the DW3's evidence.
Right.
And even the plaintiff's witness, they vacated the premises in March 2011.
11. Correct. That
Suit
is
was filed in July 2011.
absolutely
So
correct.
at the time of filing of the suit, there were no tenants.
So let the record reflect that both councils are in agreement that the tenants left in the month of March 2011.
And suit was filed in July 2011.
Those are matter of record which cannot be denied. Which cannot be denied. So I will come to that, Your Lordship. At the outset, what I would like to mention, Your Lordship, is that the question of liability has not been raised. Now, the learned trial court has held that the defendant number 1 appellant is responsible and liable for payment of compensation and damages. That aspect has not been challenged. It is only on the quantum.
Yes.
So, before I proceed any further, Your Lordship, and I would like to quickly run through the facts of the case with Your Lordship so that we have a proper grasp of the entire thing, Your Lordship. Now, I am the owner of one LSC number 2008 of 1987. Now, as your lordship may have observed after visiting Aizawl, most of the lands are quite hilly. So the
Yes.
land is like this.
Yes.
My land is located here at the top, whereas the land of the defendant is located below. So once he started excavating or cutting down some portion of the
Yes,
earth,
yes.
it made the upper portion quite unstable.
Yes.
That is the crux of the case. So sometime in the month of March 2011, Your Lordship, the February-March of 2011, that is when the defendant number 1 appellant started his construction. That is cutting portion of the hillside. Thereafter, I came to learn that sometime in the month of March, some cracks had started developing in my Assam type building. So immediately, Your Lordship, this is very crucial. I lodged a complaint to the Deputy Commissioner Aizawl on by my letter dated,
So the excavation started in February 2011.
yes, about that time. And I started noticing the damage to my property sometime in March of 2011, or a month later. I immediately approached the District Collector Aizawl and submitted a complaint letter dated 23/3/2011. This can be found at page 17. 17.
17. On 17/3,
23/3/11.
on 23/3/2011.
So this is my letter to the DC saying that, narrating my story, say my 3-story Assam type house number so and so, so and so. So basically, I asked them to come and conduct the spot verification.
Okay.
And please do the needful.
I've noticed the letter. Okay.
So at page 19, Your Lordship,
Yes,
if Your Lordship can kindly turn. On 24th of March, my letter is 23rd. Immediately, a stay order was issued under section 1333 of CRPC against the defendant number 1. Please stop everything. So thereafter, at page 20, Your Lordship, at the next page, there is a notice for conducting a joint verification or spot verification. And copy was also furnished to the defendant number 1.
Page?
20. Page 21 is the geotechnical
Page
assessment.
20 is the?
Page 20 is the notice for conducting spot verification.
Okay. Yes.
So in this copy, notice was also given to the defendant.
Page 21.
Page 21 is the report.
So this report has been brought to my notice.
Yes, but I would like to just read one or two lines, Your Lordship. At the on the right left hand side, second from the bottom, cause is written. Your Lordship has it?
Causes, yes.
Causes. Due to house site development of Pusilal Tranpuya without any precautionary measures. Pusilal Tranpuya is the appellant. The house site development has been done since the ending part of February, and then the present development of cracks started on 23rd and 24th March 2011. So that was the finding. And at page 22 is the recommendation.
Page 22.
Yeah, it's the continuation of the report.
That has been brought to my notice.
No.
Recommendations.
The reason why I would like to read out is because my learned friend has stated that there were no tenants when I filed the case in July. This is the reason I did not have any tenants. The recommendation and suggestion. Number 3, the inmates of Pusilal Rinoma, that is the plaintiff house, namely Pureng Kuma with 4 family members, Pima Biake with 2 members, and Piming Thani alias Mingte should vacate the house.
Okay.
They were ordered to vacate the house.
So that he is not disputing. He is disputing only the compensation amount.
No.
And the
My learned
mental
friend had also
stability.
disputed the fact that my property was remained vacant
From
from March
because
because they left out of but which is the report says otherwise, because I was directed to vacate the premises. In any event, Your Lordship, page 23 is the joint inspection report.
we can actually we can narrow down to the compensation amount, I think.
We can do that. In any event, Your Lordship, so that is the situation. As far as liability is concerned, I think it is an accepted fact. They're not denying that. So I'll come to my arguments on those
Page
points.
24, na?
Yes, Your Lordship. Page 24 is the report.
Page 24.
Page 23, para 1.
Joint inspection report, yes.
The area of the subtype house.
Now, coming down to the arguments, Your Lordship,
Yes.
on the issue of Exhibit P13. At the outset, what I would like to mention is that my learned friend has stated a lot of things about Exhibit P13 being not reliable. The court could not have relied on it. But the fact of the matter is, my learned friend has never challenged this Exhibit P13. This was never challenged by them, number one. And it is not the case of the appellant that this Exhibit P13 is a fabricated document. It is not their case. Their case is that the author was not produced, that's why it could not be relied upon. That is their main case. It is not their case that this Exhibit P13 is a fabricated document, nor is it their case that P13 could not have been relied upon, in as much as they have never challenged this Exhibit P13. Now, their challenge, Your Lordship, I think we need to be very clear. Their challenge is only on the rate that was mentioned in Exhibit P13. Now, my learned friend has stated, court witnesses had clearly stated that the rates were, the prevailing government rates were utilized. He is only bothered on the quantum. He is not bothered about the area. He is not bothered about which this Exhibit P13 being fabricated, not being genuine. They're not bothered about that. It's only on the quantum. 734. 2022, Volume 1, GLT 734.
I need a copy of this also. Yes.
I would like to take Your Lordship's attention to para 12 at the next page. Your Lordship has it?
Yes.
May I read, Your Lordship?
Yes, please.
In the case of R.V. Venkatachala Gounder versus so-and-so, the Honorable Supreme Court was pleased to hold that ordinarily an objection to the admissibility of evidence should be taken when it is tendered. It was held that the objection should be taken when the evidence is tendered and once the document has been admitted in evidence and marked as an exhibit, the objection that it should not have been admitted in evidence or that the mode adopted for proving the document is irregular cannot be allowed to be raised at any stage subsequent to the marking of the document as an exhibit. This is very important, Your Lordship.
Yes, yes.
The objection that it should not have been admitted in evidence or that the mode adopted for proving the document is irregular cannot be allowed to be raised at any stage subsequent to the marking of the document as an exhibit. It was held that this proposition is a rule of fair play and the crucial test is whether such objection would have enabled the party tendering the evidence to cure the defect and resort to such mode of proof as would be regular. It was further observed that the omission to object becomes fatal because by his failure, the party entitled to object allows the party tendering the evidence to act as on an assumption that the opposite party is not serious about the mode of proof. In the aforesaid case, it was further held that a prompt objection does not prejudice the party tendering the evidence as in the event of finding of the court in the mode of proof sought to be adopted going against the party tendering the evidence. The opportunity of seeking indulgence of the court for permitting a regular mode or method of proof and thereby removing the objection raised by the opposite party is available to the party leading the evidence. Such practice and procedure is fair to both parties. Failure to raise a prompt and timely objection amounts to waiver of the necessity for insisting on formal proof of document, the document itself which is sought to be proved being admissible in evidence. So as I had mentioned earlier, Lordship, they did not raise any objection when it was exhibited and admitted. And my learned friend had read out the portion of the judgment which clearly stated that the original, the exhibit P13 was compared with the original before it was exhibited. Original was compared. And also, one judgment which the judgment which my learned friend had relied on, this 2010 4 SCC 491. 2010 4 SCC 491. I think my learned friend had already read it out, but I would just like to
2010 4
SCC 491. My learned friend had relied on this.
Yes.
So I would just like to raise one issue on this. I think the relevant paragraph which my learned friend relied upon was at para 31. May I read, Your Lordship?
Yes.
It says, under the law of evidence also, it is necessary that contents of documents are required to be proved either by primary or by secondary evidence. At the most, admission of a document may amount to admission of contents, but not its truth. Documents having not been produced and marked as required under the Evidence Act cannot be relied upon by the court. Contents of the documents cannot be proved by merely filing in a court. Meaning that you cannot just produce a document. It has to be exhibited, marked as
This is
exhibit as per
relating to
Evidence
which
Act.
document?
Yes, Your Lordship.
This is relating to which document?
This is relating to Exhibit P13, the building valuation report. So out here, what the exact import of this particular paragraph, as per my humble interpretation, is that unless you produce a document and mark them as an exhibit under the Evidence Act, it cannot be relied upon.
Yes, cannot be relied, yes.
But in our case, it was exhibited as provided under the Indian Evidence Act.
Yes.
It says contents of documents are required to be proved either by primary or by secondary. Now, coming to that, one has to understand the meaning of proof as per the Evidence Act, Your Lordship. Section 61 of the Evidence Act, Your Lordship, or the similar provision is there in the BSA.
So now we will go to which
Exhibit P.
BSA or Evidence Act? In this case,
We can go either way, Your Lordship, because the same provision is also there.
Section 61. Yeah.
Proof of contents of
And
document.
in BSA?
My lord.
In
In
BSA?
BSA, it's Section 6. Same thing, Your Lordship. Should I rely the BSA or
no,
evidence?
Section 61 will suffice.
My lord. Section 61 says the contents of documents may be proved either by primary or by secondary evidence. Next, 62. Primary evidence. Primary evidence means the document itself produced for inspection of the court and inspected by the court. As such, it amounts to primary evidence. Now, coming to section, and then one more provision I would like to read out for Your Lordship's attention, Your Lordship, is Section 114. Section 114 regarding that presumption that the court may draw. May I read, Your Lordship?
Yes.
Section 114 of the Evidence Act.
I got your point. You want to say that according to circumstances, presumption according to circumstances.
No, it says, in a way, yes, because the common course of business has been followed in a particular issue. That
got your point.
illustration number F. So in our case, it is not the case that the plaintiff requested the authorities, please come and do evaluation of my building. No, it was under the direction of the DC. The DC said that your house has to be dismantled and accordingly directed the concerned authorities to do the evaluation. So, the court may presume the existence of any fact which it thinks likely to have happened regarding being made to the common course of natural events, human conduct, and public and private business in their relation to the facts of the particular case. So, that the common course of business has been followed in particular case. So, the common course of was followed in this particular case. It was under the direction of the DC that my property was dismantled, and before dismantling it, it was
All right.
valuation was done. And looking at page now the order for the order is at page 26, Your Lordship. Page 26, order of the DC.
Order of the DC, yes.
Fifth line from the top, Your Lordship. With this being the situation, Your Lordship has it.
Yes.
Mr. P.C. Lalinoma's house should be demolished immediately. See, so it was under the order of the DC that my house had to be demolished. And the reason for demolition was due to the negligent act of the appellant, which they have not denied. In any event, Your Lordship, at Exhibit P13, which is at page 30, Your Lordship will see that it has been duly signed by the page 31 by the estate officer, PWD, building division.
Yes, yes.
Oh, everything is there. So proper channel, proper course of action was followed, and by relying on, by invoking the provisions of section 114 illustration F, it can be assumed that this is a factual thing. Now, in any event, Your Lordship, again, I would like to reiterate that it is not the case of the appellant that this is a fabricated document, nor have they challenged this Exhibit P13. Now, another point that I would like to raise is regarding burden of proof. Burden of proof, Your Lordship, is distinct from the onus of proof. For this, I would like to rely on 2006, Your Lordship. 2006, Volume 5, SCC 558. What I would like to...
Volume 5 SCC
558.
558.
8. I've given the citation. Now, what I would like to point out in this is that the
This also.
burden of proof is distinct from onus of proof. Para 19, Your Lordship. Your Lordship has para 19.
Yes.
There is another aspect of the matter which should be borne in mind. A distinction exists between the burden of proof and onus of proof. The right to begin follows onus probandi. It assumes importance in the early stage of a case. The question of onus of proof has greater force. Where the question is which party is to begin, burden of proof is used in three ways: to indicate the duty of bringing forward evidence in support of a proposition at the beginning or later, to make that of establishing a proposition as against all counter evidence, and an indiscriminate use in which it may mean either or both of the others. The elementary rule in section 101 is inflexible. In terms of section 102, the initial onus is always on the plaintiff, and if he discharges that onus and makes out a case which entitles him to a relief, the onus shifts to the defendant to prove those circumstances, if any, which would disentitle the plaintiff to the same. I would like to read out one more judgment, Your Lordship. Next one I would like to rely on is this 2003 Volume 8 SCC. 2003 Volume 8 SCC 752.
752.
I apologize. Sorry, Your Lordship. 2003 Volume 8 SCC 745.
Bit out of this also. But it is 745 according to him. Go back to 745. Yes. 745.
Para 16. Para 16, Your Lordship has it?
Yes, yes, yes.
May I read, Your Lordship?
Yes, please.
Reliance is heavily placed on behalf of the appellant on the case of Ramji Dayawala and Sons Private Limited, so and so. The legal position is not in dispute that mere production and marking of a document as exhibited by the court cannot be held to be a due proof of its content. In its execution has to be proved by admissible evidence, that is, by the evidence of those persons who can vouchsafe for the truth of the facts in issue. Evidence of those persons who can vouchsafe for the truth of the facts in issue. So, The situation is, however, different where the documents are produced, they are admitted by the opposite party, signatures on them are also admitted, and they are marked thereafter as exhibits by the court. We find, so I'll just leave that. So my reliance is basically that the evidence of those persons who can vouch safe for the truth of the facts in issue. Now, coming back to the court witness number 1, page 195, Your Lordship. Para 58, page 195. Of the paper book, Your Lordship.
Para 51.
No, para 58,
Para 58.
page 195.
Yes.
Your
Para
Lordship has it.
58, yes.
The court witness number 1 stated that he retired from the service in the year so-and-so. He stated that he was posted as so-and-so, Aizawl Building Division from the year 2009, and building valuation in favor of Mr. So-and-so within LSC number so-and-so was forwarded to him by his subordinate for approval, Your Lordship. This is not the case that he just blindly put his signature. For approving a document, I think it would be safe to assume that that concerned officer would have done his homework, read up what exactly am I approving. So in a way, he is also an author, co-author, so to say. He may not have drafted it from the scratch, but he is someone who can vouchsafe for the authenticity of the document. And this person, having approved that exhibit P13, he has proven the contents of the document because he approved it. He's one of the author. And in the next line, at the last in the next line, he clearly says that it was also stated that building valuation in favor of Mr. P.C. Lalinmo's building at so-and-so within LSC number was done as per relevant government rate prevailing at that time.
Yes.
So where is the confusion, Your Lordship? In my humble opinion, this statement in itself would satisfy all the ingredients that my learned friend had pointed out regarding proving contents. He is also the author. So that's why, Your Lordship, the learned trial court had correctly relied upon the exhibit P13 for awarding the damage compensation for damages suffered by the plaintiff. In fact, it is not a case that the plaintiff is asking for some exorbitant amount or some amount which cannot be quantified. This is entirely based on a government document. Government is saying that this is the value of your building, so I'm claiming accordingly. I'm not saying that give me 20 lakhs, 30 lakhs. No. What exactly was valued by the government, I'm claiming only that, Your Lordship. So it's 1 o'clock. We'll come back.
Yes, we can come back. Yes. Come back at 2, yes.
Yes, we'll wrap it up quickly, Your Lordship. We'll finish off quickly. I'll finish.
Oh, no problem. In fact, I will take 1 day's time to ask some questions if I want to.
Yes, Your Lordship.
Tomorrow. Maybe
Absolutely.
tomorrow, maybe on Monday.
No
Tomorrow is
problem.
Friday, no?
Yeah, tomorrow is Friday.
Friday. Maybe on Monday.
No problem, madam.
2 o'clock.
2 o'clock, yes. This notes. I'll keep it with me. Let it remain. After completion, yeah. So now it will remain here. All right. But it must be safe.
Seek your Lordship's indulgence. Can we continue tomorrow?
Yes, of course. Then I can ask my questions also.
I'm yet to
You
conclude.
won't be here tomorrow?
No, I'll be there, my lord, but I haven't concluded my submissions.
You have not concluded.
Yes, my lord.
No problem.
We'll continue
Finish it
tomorrow.
I think there's only a few
Few points.
Few more points.
Yes.
How long will it take?
Not more than half an hour, madam.
Okay. Yes, we'll continue tomorrow.
I'll give a short reply. I'll give a short reply.
You won't be
Half
short.
an hour can be few more points. Can half an hour be for few more points? I think it will be a long argument, half an hour.
We
Yes,
won't be very-
tomorrow. Yes, tomorrow. We have time tomorrow.
We have waited for 13 years what to do, Your Lordship. We have to try our best
13 years.
for this relief,
Okay. That's a long time.
which they are also not denying.
More than. Anyway, I'm sorry, but yeah, if we can kindly continue tomorrow. Your Lordship.
Yeah. I think so. We can. Then I'll.
You can, I mean, it's in the cost list.
Uh,
Cost list till tomorrow.
we'll have to pass an order. Short order, yes. Okay, then pass us. You can ask her to just pass to type type one order, fixing it for tomorrow. Heard both sides.
Part heard, Your Lordship.
Yes, part heard both sides, names also of the advocates, and then daily list can be put on bottom in the hearing column. Yes, of course, in the hearing column. So you can
I'm okay.
staple it. Staple it.